Dave Farnbauch joins us from Sweeney Law Firm, and interesting topic. I think I know, but I'm going to ask you to explain a confidentiality agreement.
Well, Dirk, confidentiality agreements are pretty common in what we do, which is civil litigation, where there is a settlement of a dispute, usually in connection with for the kind of work that we do, an injury claim.
Mm-hmm.
And more commonly, we do a lot of medical malpractice work. So almost every time that we resolve a matter, our clients are asked to sign what's known as a confidentiality agreement. And it's just as the term implies, it's an agreement that basically asks that the whole matter be kept hush-hush. You can't disclose that to anyone. For example, other than your immediate family or your tax advisor or whoever, you can't publish anything in the newspaper. You can't report it. For example, lawyers like myself, we all network with one another and share information about cases so that we can more effectively represent our clients. So we share information with other lawyers. We're not permitted to share the details of those cases with other lawyers so that they'll have an advantage if they're working on the same type of a case. So that's in general what it is, and it's obviously insurance companies are the ones that are, for the most part, pushing these confidentiality agreements because they don't want information to be out in the public domain about, what kinds of settlements that they're paying out, who's causing the harm, I guess the frequency of how often this happens, and so that's in general what a confidentiality agreement is.
As a victim, would there be a downside to signing one, or what should I know, I guess, before I sign one? Because it seems like to me it's settled, I'm done.
Well, there's two schools of thoughts, and I will tell you that most of the time our clients opt to settle a case on the basis of confidentiality, and they'll agree to sign the agreement because sometimes it's contingent. The matter is contingent upon your client agreeing to, in order to receive the settlement funds,
right,
they have to sign the agreement. And most of them sign those agreements. We, in many instances, try to have a conversation with our client about the flip side of, or the downside of signing a confidentiality agreement for the public at large or for consumers. The problem with confidentiality agreement is it prevents the public from learning how often these types of events occurs, how many people are being victimized by this type of an event. So there's less information out there available for people to learn about how to protect themselves. You and I have talked on Insight before about the issue of, you'll see these articles in the paper about these hospitals reporting, X number of reportable events, malpractice events occurred this year to the Indiana State Department of Health. Those statistics are all skewed because these hospitals are self-reporting, and there's not information out in the public domain. There's not newspaper reports or information out in the public about how often this happens or how much money is paid to these victims as a result of medical negligence. So it's hard for people to understand the scope of the problem if every time someone's injured, they're sweeping this all under the rug with confidentiality agreements. So it's bad for the public. But
it's obviously one of those things somebody should seek counsel before signing because there are ramifications down the road and things everyone should know what's going on before they sign anything.
Right.
Yeah. If you'd like to find out more about how you can have Sweeney Law Firm represent you in an accident or in a case like this where there's been an injury, you can find out more at SweeneyLawFirm.com before you sign a confidentiality agreement. Give them a call. We'll be right back on Insight.